Omwoyo for the first respondent submitted that as a result of non-compliance of Section 78(3) of the Elections Act by the second appellant, its appeal should be struck out. It was submitted that the said section is couched in different terms, and therefore it was only fair and meet that the said appeal be struck out with cost. Counsel for the second respondent supported the submissions of the counsel for the first respondent. This court was urged to uphold the principle of equity, as the second respondent was said to have approached the court with unclean hands. Mr. Omwoyo for the second appellant submitted that failure by the second appellant to comply with the order for security for cost was a result of the fact that it was not properly constituted, and some of the information had since retired while others had resigned. Mr. Omwoyo retaliated that if indeed the second appellant had difficulties in complying with the court order, then the best that he could have done was to seek for review of the order. I note that the issue of the constitution of the IEBC was not an issue before the trial court, and by the time the trial court gave its decision, the commission was properly constituted, and therefore the trial court cannot be, therefore the trial court did not misdirect itself in any way. And I have also noted that that was not one of the issues in the appeal by the second respondent, so it was not an issue for determination of this court. And I've just looked at it in terms of complying with the security of order for cost. And it is stated that the deposit for security of cost would, to some extent, cushion the respondents against the non-payment of cost by the second appellant should its appeal not succeed. That being the rationale behind depositing of that should be the rationale behind the depositing of cost. It should be remembered that this court was moved by the first respondent to strike out the appeals herein for failure by the appellants to deposit security. The court considered the application and declined to grant the orders sought by the first respondent, but instead ordered the appellants to deposit the same within 7 days, which order was not complied with by the second respondent. In its submissions, the second appellant has given reason for failure to comply with the orders of the court, as lately submitted by the counsel for the first respondent. If the second appellant was unable to comply with the court order, it ought to have moved the court for review of the same orders and not to wait until an objection had been raised for its failure to comply with the order. For that reason, I would have struck out the second appellant's appeal. But since even on merits, the appeal has no merits, it will not serve any purpose for the court to strike out the appeal. As a consequence of the above, I make the following orders: that all the appeals E001 of 2022, E001 of 2023, and E003 of 2023 are all dismissed for want of merit. Due to the nature of this matter, each party to bear its own costs of the appeal. Those are the orders of the court.
On behalf of
Just a minute, please.
first respondent,
Yes.
first, on behalf of my entire team, we wish to thank the court
Yes.
for its reasoned judgment
Yes.
and the settlement of jurisprudence in this particular matter.
Yes.
Secondly, my lady, we have 2 applications to make.
Just a minute. Yes.
Lady, the first application is that on behalf of the first respondent, we pray
Yes.
that we be supplied with a certified copy
Yes.
of today's judgment
Yes.
and the decree emanating therefrom. My lady, the reason as to why we are making this formal application
Yes.
is because there is a very urgent need
Yes.
for this judgment
Yes.
as well as the decree
Yes.
to be supplied both to the IEBC
Yes.
and the Speaker of the Nyamira County Assembly for compliance.
Yes.
Secondly, my lady,
Yes.
we pray that under Section 78,
Yes.
my lady, under Section 78,
Yes.
subsection 5,
Yes.
the Elections Act. My lady, we pray that you do pronounce yourself on the issue of the security for cost, which was deposited in court. My lady, we make this application because this provision, it provides that once the court has heard the parties, it needs to pronounce itself whether the security for cost is being refunded to the appellant or to the respondents. My lady, the reason being, in this case, my lady, the respondents are the successful party. My lady, for close to an year, the first respondent has been out of the county assembly. On the other hand, the first appellant has been illegally drawing salaries, benefits, and other allowances. So, my lady, we pray that the security for cost that was deposited in court, because it's 200,000, 100,000 can be dispersed to the first respondent and 100,000 to the second respondent, because now it has served its purpose. The appeal has been concluded. On the issue of cost, each party can bear their own cost.
So on what basis, Council, do I make those orders?
On the basis of Section 78, subsection 5 of the Elections Act. My lady, you have to pronounce yourself, otherwise there will be a dispute as to who is the rightful owner of this security for cost. On the cost for the appeal, you pronounce yourself and you agree with the court. But on the security for cost, my lady, the Elections Act, Section 78, subsection 5, it behoves you to pronounce. If you say let it go to the appellant, we are okay with that. But we need an express provision under Section 78, subsection 5. And especially, my lady, given the fact that the respondents are the successful litigant, it will only be fair that they be awarded this security for cost. They have incurred a lot of costs in hiring a battery of advocates, so it's only fair that they be granted this cost. The first appellant, my lady, has been drawing salary for close to an year. It's only fair that my client is being given this security for cost. She has been in the cold for a very long time, my lady. So, my lady, we urge you to properly interpret Section 78, subsection 5. My lady, we humbly pray.
Yes. My lady, this is the other
Just a
Mukua.
minute. Just a minute.
My paper have been held by Mrs. Wanjoi. My name is Omwoyo, the second respondent. Already, I've just seen my learned friend, Mr. Nyang'ara, advising to respond to Mr. Mkua's submissions. And just before he responds, I wish to submit that the second respondent's position is that we yet again associate ourselves with the submissions made by Planning Council for the first respondent. And your leadership probably to buttress for close to 6 elections are concluded. The Jubilee Party, which I represent here as leadership, has been represented by an individual who was not the choice of the party as per the statutes and regulations. And this was been submitted by my colleague. They said party your leadership has been drawing a salary, hefty salary. It is our humble submission to humility. You exercise your inherent powers and circumstances in interpreting Section 7.
But let me ask you, the judgment of the case?
It is this coach leadership which this coach leadership which issued state.
Oh, yeah,
Which
because
state issued
yeah,
black
you're
draft,
right.
which is scary. That is how we found ourselves where we are. And the leadership with humility and for purpose of fairness, we plead with you to elevate. That would not ordinarily be the kind of post the first respondent has incurred, or even the Jubilee Party. But we pray with humility that you elevate the fame on the cost that has been incurred by your leadership